Good morning, everybody. Today is Thursday, May 23rd, 2024. This is the South Coast Air Quality Management District Hearing Board. We have one item on the agenda, other than the one that was taken off calendar, which was the AQMD versus thermal solutions in regards to the order of abatement. But we will be hearing the interim variance today, and it will be in regards to Rules 203 and 1420. This is for case number 6255-3. And if you already do not know, since it is an interim variance, it is split between good cause and the 6 findings. So the first half of the hearing will be to establish good cause, and then your opening statements, if you can address that, please. And if we do find good cause and we do vote for the good cause, then we will go into the 6 findings hearing after that. So with that, who is here on behalf of Thermal Solutions?
I am.
Your name, please?
My name is Ron Reeves. Oh, the push button.
Push a button. Okay, sorry about that. I'm new at this. My name is Ron Reeves. I'm the Director of Supply Chain for Thermal Solutions.
I'm sorry, Director of?
Supply Chain for Thermal Solutions.
Okay.
REEVES. Ron, RON.
Okay, and who else will be representing them?
I'm Bill Winchester. I'm with Montrose Environmental Solutions on behalf of Thermal Solutions Manufacturing.
Okay, and on behalf of the district?
Mayor, I'm sorry, my voice is a little rough this morning. Mary Reichert on behalf of the executive officer. Thank you.
Thank you. Okay. And I'm assuming, Mr. Reeves, you will be the one and only witness, or will both of you be providing testimony?
Both of us will.
Okay. Mary, will you be having anyone from the district?
Yes, I plan to call a district engineer and also have somebody available from compliance if the board has any questions,
Okay.
but I do not intend to call them as an affirmative witness.
Okay. So all those who will be providing or may be providing testimony, if you can please stand and raise your right hand. Do you swear under penalty of perjury that you will be telling the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Okay. Mr. Reeves, you can start with your opening statement. Oh, before we do that, I did want to mark an exhibit. The one and only that we've received is from the district, so it'll be marked A, and that is the proposed interim variance conditions. Okay, sir.
Good deal. Thank you for taking time to meet with us this morning and consider our petition. I appreciate the work of the board and the district as well in keeping the citizens of this area specifically and the state in general. So Thermal Solutions manufactures radiator cores in San Bernardino. We've been doing that for over 40 years. I remember my first trip working for the company was coming down here for HR training. So we've been here for a long time. Our main product is radiator cores for the heavy duty aftermarket. So we make products that are then used to repair construction equipment, agricultural equipment, backup generators, stationary generators. It's used in tall buildings. Many of the tall buildings have a backup generator. Also hospitals. We are used in buses and trucks, over-the-road trucks, fire trucks often have our products. If there's some sort of a failure, then they need to replace it. You can't always get a complete unit to put in there. So they come to people like us and we make a replacement core. It's a lot of custom work. Everyone's a little bit different and you can't necessarily go look up in a catalog and find the listing for your 2005 Kenworth fire truck or whatever the application might be. So it's really important that we're local Because the other piece of it is, since we're in the heavy duty world, a lot of times, like, let's take an example. If you own a landscaping business and you rely on your dump truck to make money every day, you know, if that truck is down due to a heat issue, a cooling issue, you're losing that money. So you need to get back up running quickly. So you can't wait for that unit to be shipped from across the country to get back up and running. So it's really critical that we are in kind of the areas that we serve so that we can get these people back up and running quickly. So that's, the next group is obviously we are a manufacturer. So then we sell to whether it be a radiator shop or a distributor, and they rely on our products to keep their business flowing. We don't do the actual installations. We manufacture the product. We sell it to again, a interim step. They put it together and they provide it to the customer. Kind of the third constituent is then our employees as well. We employ, I think 9 to 11 people in the plant, depending on the time of the year and something like that. So they're critical to our success, is that we can support these people where it's kind of a craftsmanship business. So it's important that we provide income and wealth to these folks so that they can support us in our job. So it's a little bit about the company. Now moving on to the petition. That's great. Wait, ready to go. So, you know, the first step is that we are or will be in violation of Rule 1420 and 203 based on the results of a airborne testing that was provided on, what was the
It was
date?
March 6th.
March 6th was
March 6th.
was the actual test date. Now, we were quite surprised by these results in that prior test, we were significantly below the standard. And when these results came back, we did a lot of looking into, have we changed our process? And we have not. Are we following the guidelines that the districts have provided? And we are, as far as some kind of testing of our ventilation systems and all that. So we were quite surprised by the results when they were returned. They were not predictable. We were not able to kind of know in advance that, oh, you know, we changed something or whatever. Nothing's really changed. So we feel that it's beyond reason for us to have known about this. And in order for us to comply with the rules immediately would essentially be an arbitrary or unreasonable taking of property. And then also, it's kind of the elimination of a lawful business. You know, if we were down for any significant amount of time to come up with a filtration system or mitigate the problem, then we are risking our business. Our customers are going to find other sources. They're going to find other solutions for fixing the problem. So, you know, it really puts us in a position where our management team would look at this and say, hey, do we really need to be in this facility and in this area? Beyond there, I'll turn it over to Bill. You want to talk about number 3?
Yeah, sure. Thank you, Ron. Just wanted to briefly touch on an element of good cause.
Sir,
and that-
before you do that, if you can please state your name, spell it for the clerk, and also state that you did take the oath.
Yes, my name is Bill Winchester. It's BILLWINCHESTER. I took the oath. So I would like to speak to finding number 3, or that the closing would be without a corresponding benefit in reducing air contaminants. And really just wanted to inform the board that we did conduct a Tier 2 health risk assessment for the lead emissions based on the test result. And the nearest sensitive receptor to the facility is 439 meters to the south. There are adjacent businesses, and we did conduct that Tier 2 HRA based on those receptor distances and using the test result from 2024. While using a highly conservative operating schedule of 24/7, 52. The health risk levels for cancer risk show that both residential and offsite worker would be below 1 in a million, well below 1 in a million. Additionally, the tool was not cooperating with me. For some reason, if you change the operating schedule, it breaks the worker adjustment factor function. So I was only able to get the residential receptor results out of the model when I put in the 9 hours per day, 4 days per week, 52 weeks per year. But that result was less than 1 in 10 million for the MICR. So I guess the results of that analysis indicate that in conjunction with your standards, that granting the variance would not cause a significant health risk to actual receptors.
Okay. Does that conclude your opening statement?
Yeah, that concludes our opening statement.
Ms. Reichert?
Thank you. As noted in the petitioner's petition for an interim and regular variance, the procedural history of this case is a little bit unusual. Initially, this came in as an ex parte variance request, and as the board knows, there's a very quick turnaround for district staff to review and make a determination on a position. Upon initial review, district staff believed that the lead NESHAPs applied to this facility, and therefore it would be a prohibited variance because it would exceed the lead NESHAP. So the initial recommendation was to oppose that ex parte variance because the rules prohibit permitting such a variance. As such, petitioner had withdrawn that variance, and we were going to proceed with an order for abatement, which was filed by the end of that week. Upon further review of the facility and the NESHAPs, myself and engineering staff determined that the type of work done at this facility and the permits that they operate under that do not trigger either of the lead NESHAPs. So upon that discovery, we informed petitioner that we would not be opposed to actually proceeding under a variance. And they made the determination that they would then proceed under the variance process again instead. So while under normal circumstances, the amount of time that has elapsed since the initial discovery of the exceedance would be too long in the district opinion to meet the good cause standard of acting expeditiously due to the circumstances that occurred here and the district's mistake in advising petitioner that the NESHAPs applied and our opposition to the initial ex parte, the district would not oppose the good cause finding for the granting of the interim variance. I do want to speak briefly to the fact that this is lead, which is concerning and has been a concerning factor from the very beginning. As was noted immediately when we thought the NESHAPs were triggered. Staff quickly calculated and determined a reduction in the throughput of the facility, of the amount of input that they put in their lead pot would basically be an equivalent to the maximum limits that are in the rule based on what their maximum throughput is in their, or the maximum that's permitted under their permit. So we are proposing a limitation in the conditions that would be less than what is allowed in their permit in order to reduce any potential impact to the community. So with that, the district is not opposed to the granting of good cause. Thank you.
Thank you, Ms. Reichert. Okay, sir, did you want to go ahead and start giving us and since you are the witness, did you want to go ahead and give any more information to us in regards to in data or any type of information or testimony that you want to present? Since you don't have an attorney that's going to ask you Q&A.
Sure. Yes, I just want to reiterate the point that we did act prudently and judiciously as we move forward through this case. We understand the urgency of dealing with this, and I don't want to get into too much detail right now because there's a lot of kind of engineering behind it, and I respect the time here. But we did the best we can with the timing and dealing with the vendors for the various services that we need. So we did act prudently to deal with this case. And that's all I have.
Okay, Ms. Riker, did you want to question?
I don't have any questions at this time.
Board members, any questions for this witness? Mr. Pearman.
So, so as I understand it, once the test came back in March that was failed, that you were then immediately in violation of Rule 1420, right?
That's correct.
Okay, and then you moved quickly to try and set an emergency, and then the variance process were dissuaded by the reaction by the district that you needed an order for abatement instead, and you had to go through that process before you could really reinstitute the setting of the variance hearing, correct?
That is correct.
Thank you.
Mr. Balagopan, did you have questions?
No, I think I've heard enough for good cause. I do have questions, but I think I'll reserve that for
For the
the next
merits.
phase, the merit of the.
Okay, Mr. Ali, did you have any questions?
No, thank you.
Okay, the only question I had, and Madam Clerk, you may be able to give us the answer. So there was no actual separate timeline, right?
That was in the original petition, which was the -1 case was filed with the ex parte. They have not done another timeline, other than.
What's on 15?
That questions 15 and 16.
Yes.
In the front.
Okay, all right. So I didn't have any other questions in regards to that. Did you also want to have Mr. Winchester provide any more information?
I will just sort of augment the discussion about the prudent action. We were informed of the preliminary test results by the testing company, and we acted immediately to contact Thermal Solutions. They acted immediately to reach out to an emission control system vendor and ask for a quote for a retest. We got all of those items fairly, moving fairly rapidly, as well as on the date that the source testing company actually confirmed the test result was final. That is the date that the original ex parte emergency variance petition was submitted.
Thank you. Ms. Riker, did you have any questions for Mr. Winchester?
No questions.
Okay, board members, do you have any questions for Mr. Winchester?
Just for the record, Mr. Winchester, the source testing company is the same company you represent, correct?
Montrose Air Quality Services, they're a separate division of our company under separate management.
Okay, thank you.
Okay, anything else? All right, so you can go ahead and make your statement, and I don't think we have anyone online to, as members of the public. Is that correct, Madam Clerk?
Is there some comments?
Not one of my witnesses or anything, so.
There is, Madam Chair, there is someone on in the attendees, but I can't ascertain. They don't have their hand raised.
Okay, no hand raised. Okay, all right, thank you. All right, sir, Mr. Reeves, you can go ahead and then make your closing statement in reference to good cause. And if you can follow again, the items 1 through 4 for good cause.
Thank you. So once again, admit that we are in violation of Rule 1420 and 203. We're surprised by the results of this test, as our previous test in 2019 was significantly below the standard. We feel that the conditions that it would take to control the situation is really things that we cannot do and continue to operate our business. This is an integral step to the process. And so it's not something that we can just stop and have products that we could sell. So we feel it is an arbitrary and unreasonable taking of property, or it would essentially cause the practical closing of this business. And then to summarize Bill's points, we feel the risk to the outside community is minimal. I don't know if I can have a word that's small enough to really, that shows the exposure that we're really talking about here. We're talking very small numbers. We also want to then talk about, you want me to go into these points too?
Well, if you don't mind, I'll continue. Sure. So with respect to the good cause, the applicant has given consideration to curtailing operations, and as they've indicated, they cannot do that without risking their business. However, during that variance period, we have come to terms with district staff on what a reasonable curtailment might look like, or reduction in the operations during the variance period. And so condition number 5 of Exhibit A indicates that they're going to limit the charging of the lead ingots into the lead pot furnace based on these numbers, which is below what they're currently permitted to do. So they have given consideration and have accepted conditions to reduce their emissions. And then additionally, they plan to monitor that lead ingot charge rate. They will keep records. They are obligated to then subsequently report those records to the inspector monthly. So there will be some level of monitoring and reporting to the AQMD there.
That's the end of our closing statement.
Thank you. Ms. Reichert?
Thank you. As for the reasons noted in my opening, the district is not opposed to the finding of good cause. Thank you.
Thank you. Okay, I think we can go ahead and go into the deliberation for good cause. I've seen all of the documentation that has been presented to us. I feel that there is good cause to go into the 6 findings from the documentation that you provided, as well as your statements. So I understand that this is a difficult situation especially when you're not expecting something to fail. So, but that's my opinion. Anybody else? Mr. Pearman?
I concur in full.
Yeah, I do concur on that. I'll just go through the 4 findings we have to make for good cause, that they are in violation of a rule or imminent. So we know they're in violation of Rule 1420 because the lead emissions higher than allowed by the rule. The circumstances leading to the violation reasonably could not have been avoided, because they would depend, as we heard and the data showed, that they passed the last test they did, and they haven't really changed the process, so they didn't expect the test results to show any higher amount. However, when they did find out, they were exercised diligent petitioning, and I think we heard from Ms. Reichert that that they filed for the ex parte emergency, but due to circumstances that she mentioned, that we are hearing it in a delayed fashion. But I think they were diligent in filing for the ex parte, and due to the misunderstanding of the NESHAP that this occurred. So, and the denial would, as we heard, there is an impact on the public health and adverse, but I think we heard from Mr. Winchester about less than 1 in 10 million, and I should have asked for the number, but I'll reserve that for the next phase. But it would cause a unreasonable and unavoidable adverse to the petitioner, as we heard, So for all those, I do believe I can make the same good cause finding and, and make a motion if you like to,
That's fine.
So in the matter of thermal solution manufacturing case number 6255-3, I move that we find good cause to proceed for a hearing for an interim variance in absence of notice to the public based on our discussion ability to make the findings for good cause. I just wanted to add, even though it's interim as there's no notice, but because there was initially an OA, there was a public notice. So in a set, it's sort of different. So the public was notified, even though they, were not notified of the interim, variance.
Mhm.
So anyway, that's, I conclude my motion.
Do I hear a second?
Second.
Okay, thank you. All right, any discussion on the motion? Hearing none, how do you vote, Mr. Ali?
Aye.
Dr. Abraham?
Aye.
Mr. Pearman?
Aye.
Mr. Balagopalan?
Aye.
And I also vote aye, so it's unanimous that we'll go into the 6 findings now. Okay, having established good cause. All right. So let's go ahead and we will do the process again of allowing you to make an opening statement. However, this time it'll be to address the 6 findings.
Okay,
And Mr. Reeves, did you want to begin?
sure. All right, so Thermal Solutions, again, manufactures radiator cores for the heavy duty aftermarket. Our products are mainly made out of copper and brass. And then, to make them watertight, the ends are dipped in a solder bath that is currently comprised of 30% tin and 70% lead. This particular formulation is used because it gives us the widest range of temperature control, and it ensures the best result as far as quality and just gives us some variation for temperature. So if we're doing 2 products, one after another, and the temperature drops a little bit, it's still going to give product. And so it gives us the widest range compared to other alloys or mixtures. Again, our products are used in the aftermarket for heavy duty. So the applications are anywhere from construction to stationary generators, agriculture, over-the-road trucks, off-road vehicles, dump trucks, fire equipment, and backup generators as well. It's also backup generators are something that's typically found in some sort of, in all the waste treatment plants. They have waste system. I've been in plenty of waste treatment plants inspecting their equipment. So again, we admit that we violated the Rule 1420 and 203 as far as the emissions of lead from our solder pot at our facility in San Bernardino. We were quite surprised by this test result, as prior test results were well below the standard. We have done significant research in evaluating our process and the equipment and determined that there's been no changes since 2019 and that the process that we're following is the same as it was back then. So the condition really was beyond our reasonable control. And so we feel that it's an arbitrary or unreasonable taking of property if we're forced to stop at this point in time, because we'd have to just shut down the facility, and that you can't sell a radiator that's leaks. You're not giving the customer anything better than what they have right now. It also, then would stop a business that's lawfully conducted. We've been in San Bernardino for over 40 years. Through different names, we've had changes in ownership, but we've been there a long time. And we appreciate being in that market. It's obviously been good to us. We appreciate the workforce that we get out there, our management team, who is all local to the market, has really supported the company well, and we appreciate their work. We don't see that there would be a measurable improvement to the community in regard. We're talking very small numbers here as far as how far over the standard we are. And, Bill will dig in a little bit to the details. So you want to go ahead and just do that right now?
Sure. I mean, would you like me to go ahead and cover 3 through 6?
Yeah, go ahead. That's fine.
Okay. So as Ron was pointing out, and as we described previously, we believe that the closing or taking would be without a corresponding benefit in reducing air contaminants. Based upon a tier 2 health risk assessment that was conducted, we did not find that there was a significant health risk posed by the current emission rate. Additionally, we've given consideration for curtailing operations in lieu of obtaining this variance. I think it's been made clear that the business would be put at risk if they were to curtail operations. However, Thermal Solutions has been willing to accept an ingot charge rate limit in the variance so that they can curtail to the maximum extent feasible for them and their operations. And they will monitor that ingot charge rate and provide those records to the Air District in a structured format.
Okay, thank you. Ms. Reichert?
Thank you. Subject to the conditions presented here today and the testimony, the district is not opposed to the granting of this variance. Thank you.
All right, so is there anything else that you wanted to state, Mr. Reeves, and or question Mr. Winchester to establish any more information?
No.
Okay, and you, Ms. Reichert, did you want to present any of your witnesses?
If I could just ask a brief question, I just wanted to confirm that you are you're willing to comply with all of the conditions as presented in Exhibit A?
Yes.
Okay, thank you.
Thank you.
Okay, and then did the board have?
Yes, I'm gonna
Yes, I'm
ask
sorry, do
them.
that.
That's
Okay,
okay.
sorry.
All right, does anybody from the board have any questions for either Mr. Reeves or?
Yeah, I do. Mr. It's for Winchester, but you mentioned you did tier 2 health risk assessment, and you were not able to get a number for the workers. Is that what it was? Something was the software?
Yeah, the tier 2 assessment, something broke in the formulas, and since the spreadsheet is locked, I couldn't.
The one that is
troubleshoot
on
it.
the website?
Correct.
Okay. What about the residential? What was the number?
The residential number was 8.32 e to the minus 9.
Oh, okay. Okay, so it's so in terms of 10 in a million, it would be
It's less than 1 in 10 million.
less than 1. Yeah. Okay, 10 to the power minus 9, right? Yeah, 10 to the power minus e to the power minus.
Oh, I guess that would be 100 million.
Yeah. So yeah. What was the actual number you got? E
to the minus 9. 8.32 e to the minus 9.
Minus 9. Okay.
Correct.
All right. That's using tier 2. Yeah.
Correct.
Let me couple of things. In the petition, it says that you have a rain cap on the stack. Is that correct?
Yes.
And so does your employee go up there on the roof to do any kind of housekeeping, anything like that?
We have a kind of a standard maintenance protocol that we follow, and it's pretty infrequent. I would say that it's something that's semi-annually.
And you're aware that if the the plume is exiting the stack, it's going to hit the rain cap. It's going to, some of it's
Right.
going to settle down on the building, right? On the
Right,
the roof, basically. Correct?
right.
You think you would. Now, there's also a provision in the rule saying, and if, I don't know if you have a copy of the rule, 1420.
Yes, I do.
1420, if you look at G, let me see, let me get a copy.
It's on the back of their petition.
Yeah, I have mine marked up, so I know it. I thought I did. There's a provision that says you have to remove the rain cap. Are you aware of that? And let me see if I'm reading it wrong. G, housekeeping, sorry, H4.
What page is that? Uh-huh.
It's on page 7, 1420-7. H 4.
Yeah, no, sir. Okay. I think that is that as far as just the cleaning and test the housekeeping thing, or it needs to permanently be off of there?
I'm going by the rule. It says remove any weather cap
Okay.
installed, so that's, and
Okay,
that's on the housekeeping requirement. It is under
Right.
that section, but
yes,
in I can see some benefit in, because it settles down on maybe on the roof versus dispersing further, but the purpose of it, we won't go into it, but that's the rule requirement that there should be no rain cap.
okay. Obviously there is, and so obviously we weren't aware of that regulation. We have looked at other alternatives at other facilities that I've been on the roof at. I've never been on the roof in the San Bernardino plant, and we have others that have kind of a U shape. So we certainly will investigate that and get that changed.
Okay.
Very quickly.
And when you said, what about you haven't been on the roof, as you mentioned? So when was the last time has anybody done any kind of maintenance on the roof to look for lead dust that accumulated on the roof, to your knowledge?
I don't know that information specifically.
Okay, so if
Can we bring in swear in another person at this point?
Yes, do you have that person here?
Yes, yes.
Okay.
So we have our local plant manager, Maureen Baker. So I'd like to ask her to join us.
Okay, Ms. Baker, did you take the oath, Ms. Baker?
No.
Okay. You can raise your right hand. You swear under penalty of perjury that you will be telling the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Okay.
This is on.
Yes.
Okay, so we do have a maintenance
I'm sorry,
person.
Ms. Baker, can you spell your name for the
My
record?
name is
and your
Maureen.
title? Yeah,
Maureen Baker, Baker,
and your title is,
General Manager.
thank you. Sorry, go ahead.
We do have a maintenance person at the facility and he goes on the roof monthly, every month, to check the exhaust, also to check the filters of the units up there, the AC units. So he goes up there monthly, he checks the exhaust, he checks the AC units. And I know there is a rain cap on there and I would have to ask him if we take that off, because he has mentioned that to me before.
Has he mentioned to you if he has seen any kind of accumulation on the roof?
Accumulation only inside the unit, which he takes out monthly.
So you have, when you say inside the unit, somebody cleans it?
Yeah, he cleans it.
So do you know if that was done before the source test that was conducted?
I don't know how far before the source test.
Okay,
I could find that out, but I don't know at the moment.
so, okay, If I were to propose a condition, Ms. Baker, to have again, a monthly cleanup of the roof for any accumulation of lead dust, is that something that, using one of the approved methods in the rule for doing the housekeeping, would that be something that the facility can do?
Yes, yes.
Okay. So, and you're aware now that the rain cap, according to the rule, has to come off.
Yes.
Okay. Let me go on to I know that the condition says to reduce, you make about, according to the petition, 15 to 20 cores per day. Approximately how many pounds of lead do you have to, ingots you have to use to do that?
We use between, well, probably 2 or 3 a day, sometimes 4. It just depends on the size of the units that we're putting in the pot.
And what do they weigh each ingot?
Each ingot weighs 9 pounds.
9 pounds, 9 pounds. So, and how many, 2 to 3, depending on the size. So what's a max? Just a number?
The max daily is 4 to 6.
4 to 6, so 9 6s. Let's say it's 9, 4 to 6, 6, 6,
54 pounds.
6, 9, 54 pounds.
Yes.
So that's, but then it says, condition number 5 says you'll reduce it to 54 pounds. Well,
Right.
that's what you're doing. So a reduction would be something lower than 54 pounds, if that's what,
The permit allows them to do more than that. That's just how much they're doing currently based on their current business. So the permit does give them the ability to go well above that charge rate. 2,000 pounds per month is the limit in the permit.
right.
And the variance condition is limiting that to 972 pounds per month and 54 pounds per day. There is no daily limit in the permit currently.
Correct. Okay, fair enough. So that's, and how many cores would that be? You're doing 15 to 20 cores, but that'll vary depending on the size of the cores and so forth.
Correct.
Okay. I thought I heard that you do repairs. Do they bring in?
No.
No, not at all.
No.
So you do custom, you look at whatever the radiator that they have issues of, and you build to that specification. Is that what it is?
Yeah, our customers call us, they tell us the specifications, and then we build it from there.
In there. So the only time lead is used is in the pot when you do the soldering, basically, for the
Correct.
tubes, the
Correct.
both top and the bottom, basically. And but there's no other source of emission of lead where you do any repair, grinding, or removing the solder or anything like that.
No.
Okay.
There's like a wire soldering that's kind of part of the same process, so there could be just a little hand soldering touch-up quality related issues, but it's all in the same area, and that's very small. We go through maybe 25 to 25 pounds of a wire solder a month. It's very
When you
tiny.
say in the same area, is that also been ventilated to or it's in a separate workstation, basically?
It's in a separate workstation.
And it's not ventilated or
It's
no
not
pickup, so-
ventilated because the quantity is so tiny, yes.
Okay,
And it's indoor.
It's indoor.
right. Let me see what else I had. Now, as far as I think Mr. Winchester mentioned, he did the health risk assessment. So you're in a commercial business location, I mean, a heavy duty manufacturing, or what kind of location is that where your facility is located?
It's a light industrial area. It's just warehouses.
And then do you know where the closest residents or schools are from this facility?
Bill did that research.
Yeah, the closest residence is 439 meters to the south from the stack location. And then the nearest school would be, I didn't do a specific measurement, but it was probably about 3,000 feet away.
Okay. And when you did the risk assessment, you assume was the same rate as the sources?
Correct. And I did not add any sort of consideration for a capped point source. So,
Right, but we
so
don't
we
know what-
modeled it in accordance with how it should be with the rule.
Right, and if you model with the cap, and then there's a different velocity that, you know, you have to take into account, so that might even make it higher potentially.
I would say that's a fair statement for very close by sources or
Yeah.
receptors.
Right, okay. Now, are there plans to do, I know you're looking, you mentioned a vendor for a bag house. Oh, some kind of filtering system. What's the status? What is the plan regarding that?
The plan is kind of two sources. You know, we're looking into some sort of HEPA filtration system. We have contacted potential suppliers for that, and we're in discussions on how that system would be developed. At the same time, we've reached out to our landlord because we'd be modifying the building if we put this system on the roof, and there would be a weight consideration. So we're trying to look at the big picture and bring all the elements in. You know, there's the air quality system, there's an engineering piece, is this construction where we need building permits and all that. So we're trying to bring all those elements together, looking at various options. You know, does this filter be inside the building? Does it be on the roof? It's a little, there's a lot of complexities to this. We need to control the airflow across the pot as well, because if we're sucking too much air across the pot, then the temperature drops and we start running into quality issues as well. So there's a lot of engineering that sits behind this as well.
So how many months are you away from making some kind of decision on regarding the control system, and what are you going to do?
We're at the behest of these suppliers. It's taking longer than I really appreciate to get the information that we need. So at this point, I don't think we can really give a firm date that says we'll have it up and running by X date. We're being as expeditious as we can. At the same time, we're going down a second path in that, you know, this increase in the test result. We got to know why. Why did that happen? Right? And right now, today, I don't have the answer to that question. So we are going to do some retesting to validate that test result. As I said earlier, we are looking at all of our equipment and did we miss something as well? So we're going down the two paths of validating the test, and at the same time, getting the process started for a filter system. So if that's the right solution, we'll be ready to go and be proactive with it.
And that was actually my follow-up question. When you're going to do the retest, it looks like you're going that path. Do you have time frame when that might occur? Or
again, we're looking at multiple sources too. So we're trying to consider all the variables that could come into play here. So the one quote we had was like 3 months to get the test redone. So we're looking for other sources that could do it quicker and maybe give us a second fresh set of eyes on it, so that we can, again, if they get the same result, then there's no doubt that that was a result. So we're actually working on 2 separate quotes in addition to the company that did the last test.
Montrose.
Montrose.
Okay. Let me see if I have. Oh, and you mentioned you have to look at the airflow, and you also aware in the rule it says you have to. The design is as per industrial ventilation guidelines.
Right.
So that's
Yeah, there's a
something
whole set of
guidelines that has to be met at a minimum.
Yes.
Okay.
And there's some testing. You know, we do smoke testing
Right.
on a regular basis there to make sure that the ventilation is working properly. So.
And do you document that with a photograph or anything like that, a video, when you do smoke tests?
Yes, I have photographs. I also have videos.
Okay, photograph. Okay. Okay. Now, and this is again, maybe we can explore more during the regular variance, you know, because you mentioned you do some hand soldering and so forth. Is that were you going to look, are you considering maybe if you're putting a control system, maybe venting that station also to the HEPA system or anything like that?
Prior experience is that the volume is so low and it's kind of created some safety concerns in that trying to get the snake looking ventilation system right there with the guy, we've actually had some very close call accidents where the guy was trying to align the ventilation with the torch and, kind of burnt the equipment really. So I have very big concerns about that. And again, this is just kind of touching up for a few seconds. We don't have somebody standing there hand soldering for minutes at a time. It takes them less than 10 seconds to kind of touch up some parts.
But
per core.
Multiple times they do that.
Whatever I would say half the core count. If it's a smaller core that doesn't need it, they don't do it. So I would say half the cores do.
Half the cores do. Okay. Because so I thought there was a provision because the rule also says F1, the owner operator of a lead processing or metal melting facility shall vent emission from each lead point source to an emission control device. If you're below, if you exceed the 0.003.
Right.
So if you're exceeding the 0.03.
That kind of gets us in a new
Yeah.
world.
Okay. I just want to make you aware of that.
I appreciate that.
Okay. I have no other questions at this time.
Thank you. Madam Clerk, do we have a date for the regular variance? Because we don't have it on here.
That date is supposed to be selected today. Petitioner requested that we get through this process
Okay.
before the regular variance date was
Established.
confirmed.
Okay. Mr. Pierman, did you have any other questions?
So you've asked for the start date of this to be April 23rd, and normally we don't do retroactive. What's your logic for seeking that date to begin this variance?
The logic is that had we not been sort of pulled into a different process based on a misinterpretation of the rules, that we would have filed in a very timely manner for the ex parte emergency variance and gone directly into that process.
Good logic. I accept that. Thank you.
Riker, do you want to make a comment?
Yeah, I will just comment that, I mean, the district does and has spoken to petitioner about this and that we admit our mistake, but the board doesn't have any jurisdiction to grant retroactive variances, so.
That's correct. So we're starting it as of today and would go forward until the time when you would have the regular variance, which has to be within 90 days because an interim variance is only good for 90 days. So did you want to say
I
something?
had some follow-up questions.
Follow-up questions? Okay, so I just wanted to get through that.
Oh, yeah.
As was mentioned, we cannot put any date that's retro, that we cannot go back on any date. It has to begin today.
Okay.
So that being said, we'll go ahead and I don't know whether you have a date yet or have you discussed it with Ms. Reichert in reference to?
We have not discussed a date for the regular variance hearing.
Okay. Are we going to get a date today?
When is what based on how much notice is needed? What dates are we looking at?
A regular variance requires a 30-day published notice, meaning it has to be published 30 days before the hearing. Our very earliest date available would be July 3rd.
Yes.
And any dates thereafter.
Yeah, I'd prefer something the week following that. Either like.
Okay, let's
So
see.
folks, so is there a way we can consider the 9th?
The 9th is a Tuesday.
Yes.
Does the 9th sound good for everybody?
July 9th is fine with me.
Okay. So July 9th it is.
Yeah, that's fine.
All right.
That's good. Thank you.
And that will bring you within the, also, it will bring you within the 90 days also, because it would have been till August, your 90 days.
Okay.
Mr. Perrin, did you have something else?
No.
Mr. Balagopan, you had a follow-up?
Yeah, I wanted to go through the conditions in the Exhibit A. Winchester, Mr. So we heard, the condition 1 says you submit the application for the lead control system no later than June 14. If you heard you're still quite a ways in discussion with the landlord and with the vendors and so forth. So is that a realistic date, or are you going to be out of compliance with that date?
I think so Thermal Solutions has received one turnkey quote from a vendor that does have complete specifications, and we are already making progress on permit applications. Again, this speaks to the two paths that Ron was speaking to earlier. We know that, if the test result comes out and shows that we need the filter, we're going to want to have that option available, and we're going to want to make sure that the permits can accommodate that. So we recognize we're going to have to start the process of the permitting before it's absolutely sure they're going to need the filters.
Okay, all right. So that's, and then condition 2, it says, just if you read that, you have to reduce emission rate of less than 0.003 or reduce lead by a minimum of 99% as determined. I think it says by the most recent, that comes from the rule, but you haven't done that. It to be the date is down the road, so it determined by an approved source test, but that it's in the most recent, because that in the rule it had specific dates. That's why it referred to that in that. Okay, so and then the condition 3 to modify the lead furnace, and I saw from the petition that it's actually electrical. It's not a gas-fired unit. And
Correct.
Was that converted, or was that always been the case?
It was converted.
When do you know?
You remember when we switched from
2019.
in 2019, right around the time of the last test?
Okay, so that's why you're modifying, because of that you
Right.
didn't do a permit modification at that time.
Right.
That's part of the reason we would do a permit modification for the lead pot. The other part would be to add the filter.
Sure. Yeah.
Yeah.
Okay. The last one, and I was going to say, is in the calculation, the excess emission fee, and I was going to suggest add the language calculate, because the fee rule, you either do it as particulate or as lead, but in this case, because we know it's specifically lead, so I was going to say calculate as lead.
Mhm.
And you report it as lead emissions in your for that condition.
Right,
And
and
you'll see there's a different fee for the lead in the rule 303.
correct, and the emission rate is so incredibly low, the excess emission rate, that it's not actually triggering anything but the de minimis.
Right, but we still want for the record how much lead has been emitted during that,
Correct.
Yeah, you will pay probably the minimum fee because of the.
Correct, and in number 19 on our petition, we've clarified that amount of excess is about 0.00189 pounds per day, per operating day.
And I know, as you won't meet, my assumption is you won't meet the 99%, because of the very low grain loading you have,
True, and that's one reason.
0.003 with the control.
Right.
And since the rule allows for both, we wanted to make sure that flexibility was built in.
Built in, yeah.
Yeah.
Would you, your grain loading, I didn't see that in the report, but.
I think that, with the rule is designed that way to accommodate much higher emission sources of lead, and saying, there's some sources out there that will not reasonably hit the 0.0003 on their own. They require emission controls to do any, and they probably don't hit that even with emission controls, perhaps.
Right.
And so that's why that standard is in the rule, in my opinion. The 0.0003 though is what, because of the low emissions from this source, that is a reasonable target for Thermal Solutions still. And so we wanted that in there as an alternative, so that conceivably, and even if they have to have a control device to control their lead emissions, that they could control it down to a level that was consistent with the rule requirements without having to go all the way to 99% for such a small amount, which would effectively double the cost of the air pollution control system.
No, I totally agree. And I think that flexibility in the rule is good. Okay, no further questions. Thank you.
So you're not wanting to change the verbiage then on that?
No, because that's the rule of it. Sure, it's not,
All right.
you know.
Yeah, I agree with that. I was wondering what that was going to turn out to be. All right, so let's see here. Any other questions from board members? Seeing none, Madam Clerk, are there any people with their hands raised?
There are no members of the public with hands raised, Madam Chair.
Okay, thank you. All right, we can go to the closing statement from you, and if you can go ahead and keep in mind the 6 findings as you
Sure.
did in your opening statement.
Sure. First of all, again, thank you for your time. We appreciate the board's consideration here today. Thermal Solutions is a manufacturer of radiator cores, heat transfer products. And as part of that process, we need to ensure our products are watertight. And so the best solution from when you bring in all the elements of process and quality and materials is to use a lead-based solder, a tin lead-based solder. And so we certainly acknowledge that our current test of our emissions from our solder pot violated Rule 1420 and Rule 203. We feel that those test results were a surprise to us and that we were significantly below the results in 2019. And we've not made any changes to our process or our ventilation system. And so, we feel that shutting down our operation or eliminating this process would be an arbitrary or unreasonable taking of property. We also feel that essentially it would practically close down our business because this is an integral step in ensuring you have a radiator core that doesn't leak. We feel like we've proven that the exposure to the community at large is extremely small. And we don't feel there's any risk. We've given consideration to alternative methods and reduction of our volume and stuff. And we have an agreement on how that's going to work, and we can live with that. Let's see, we are going to minimize our volume where we can. And then we're also going to keep records and provide those records to the district as it's done. We're going to continue to do the reporting that we were doing before as far as the smoke testing. We're going to keep those records and continue with those conditions. I think that's it. Yeah, I think we're good. That's it.
Thank you. Ms. Reichert.
Thank you. Subject to compliance with the proposed conditions, the district is not opposed to the granting of this variance. Thank you.
Okay, great. Thank you very much. All right, board members, you want to start deliberation, Mr. Falcoplum?
Yes, I think the risk assessment that Mr. Winchester did for the residential shows the numbers 10 to -9. So that's very low, assuming a worst case. So I think that's one thing in the favor. I'm surprised that, well, I haven't looked at that spreadsheet. It's something that I'd suggest strongly that Mr. Winchester call AQMD, find out what's wrong with that, the worker, portion of it, the calculation. Why doesn't work when you come for the regular variant, you come with some numbers for both the worker and the residential risk. So we have it on the record that because this is lead and we do need to look at the exposure to the community. And I think, as you mentioned, the school is quite a distance away. So, and the risk to the resident using the worst case assumption is low. So I think that is heartening to hear. And in the issue of the rain cap, it's sort of a mix. I think the reason for the rain cap is, again, is a rain future. But in the case of, when the flow goes in, it hits it, it impedes the flow. The heavier lead dust could potentially settle down on the roof. And that's so I was going to propose a condition that they do more of a monthly cleaning of the roof of any using the housekeeping methods in the rule to make sure that there's nothing on the roof that could with wind blowing it gets because there's accumulation potentially that's has been going on for years now on there, and if it's not cleaned regularly, then you may have an issue. But the other thing with the rain cap being removed, that going forward, it might not be an issue, I do believe I can make the sixth finding, and I'll go through that. They are in violation of the Rule 1420 because the emission based on the last test as they admit the limit that is specified in the rule, they exceed 0.0003 pounds per hour. The non-compliance beyond the reasonable control, I think it was totally unexpected. They didn't expect it based on the last test, and they didn't seem to have changed the process unless they got some dirty lead ingots or something, but I'm assuming they maintain the same window for the lead. So requiring compliance would result in a practical closing and elimination, because then we have to say no production, basically. So, and the closing would be without a corresponding benefit. I think having heard those numbers from Mr. Winchester, I think the risk is still low based on even the worst case. So the harm to the petitioner outweighs the benefit to our call in that sense, because it's still a sort of insignificant number, because the rule does allow a certain amount of lead emissions, 0.00 pounds per hour. If you take 24 hours, it does allow a certain amount of lead to be emitted without any control. So, and so they've given, whether they've given consideration curtailing. So we do have a condition in the proposed order that limits them, albeit it's what they're doing currently, but the permit does allow them 2,000 pounds a month, I believe, so that will be, and then they will reduce excess emission by keeping to that limit, and then they will also monitor and quantify. So as I indicated, they will report it as lead and the excess emission, and then that I think would conclude. I just was going to suggest that well, I'll wait for anybody. I want to say anything. I was going to look in the rule about the housekeeping, and there might be already provision in the rule, just like I didn't want to propose a condition to remove the rain cap because it's already in the rule, and they have to do it anyhow. So the housekeeping is also in the rule also, but it doesn't specifically talk about the roof, maybe it does,
I think it may have some sort of a schedule for inspections and cleaning as necessary.
Yeah, so if it's in the rule, let me look it up, and then you don't need to make I don't want to make a motion except to, you have to comply with the rule requirements, basically.
Sure.
I wanted to speak to that because I know the area pretty well. I used to work at the Edison office that was south of the freeway, and you guys are north of the freeway. And I know that there's a lot of open area, and that also is subject to all of the Santa Anas that come through there. So there's a lot of fugitive dust that is not necessarily coming from your facility, but also may be on your roof as a result. So I wanted to mention that to Mr. Balagopalan, that even though the housekeeping rule states that you're to clean it, which we want you to do, I just also want to let you know that I at least know that it's not just from your facility, that where your facility is located, it is subject to fugitive dust from the surrounding area.
And to the point, Madam Chair, I did look at the rule, and I think it does require in the rule, but it's for facilities that process more than 10 tons per year, and you're no longer there. So I think even though you're not doing that tonnage, I think it'll be prudent to put a condition that they do cleaning of the rooftop monthly, housekeeping.
So you want on, condition number 10?
Yeah, to clean the rooftop, at least, I would say in this case, because of the situation, once a month,
Okay, are you in agreement with that?
Yes.
Madam,
Wait. Give us a second.
We do that, Ron.
You do it already. Okay, is that currently part of your inspection process?
Yes.
Okay, so I agree with my counterpart there, yes.
Does a HEPA vacuum count as a way of cleaning the roof?
yeah, the rule allows that. So,
Okay.
yeah, you can do, yeah.
Ms. Reichert, are you in agreement with that?
Yes.
Okay, so we will add a condition number 10 to clean the rooftops once a month. And you will be utilizing the HEPA
Vacuum.
vacuum.
Madam Chair, would we want to specify that they use the HEPA vacuum or just simply clean the rooftop? Mr. Balakaplon, what are your thoughts?
Well, I believe that's the equipment that they stated to us that they would be utilizing. That's the only reason I mentioned it within the condition.
And the rule does say, Mr. Ali, that clean with a wet wash, wet mop, or with a vacuum,
Mhm.
And so.
Yeah, so-
It'll be at
and
their
I think it says
discretion.
somewhere HEPA vacuum also.
Yeah,
that's in the
I just want
rule.
them to be able to have discretion so that we're not tying them to a HEPA vacuum. In the event the HEPA vacuum is broken or inoperable, then they cannot clean the roof.
What we're going to do is go ahead and put number 10 or state in number 10 that it'll be cleaning the rooftops once a month. I was asking
Sure.
what type of equipment they would be utilizing. So I'm not putting that in the condition.
Okay, perfect. Thank you.
Would it be appropriate to have some sort of a distance around the ventilation system? Is this 20, what size is the building? 30,000 square feet?
Yeah, it's about 22.
22,000, yeah, so,
And you guys only occupy a fraction of that
That's a
entire
fraction.
building, right?
yeah,
22,000.
our fraction is 22,000. So are we talking about the whole 22,000 here? Are we talking 10-foot radius?
Yeah,
Can we leave that open-ended? What's
Yeah,
the?
leave it, I would prefer to leave it open-ended because we
Okay.
don't know really the situation, but your people will observe, if they observe certain amount of dust
Something along visually
visually
apparent.
based on that, and then you do the
Okay.
cleaning. We're not
Yeah,
asking to
that's fine.
clean all the whole building, which I assume the other businesses occupying that, but
Fine.
the area around the stack, basically.
Great, thank you.
Without saying specifically the area,
Okay, thanks for that clarification.
Okay.
Okay. Any other questions from board members? All right. And we don't have anyone from the public that is raising their hand, correct, Madam Clerk?
That is correct, Madam Chair. No hands raised.
Thank you. Okay, Mr. Reeves, did you want to go ahead and make your closing statement?
Give me a second here.
Yeah, we already did that. Okay, sorry.
Deliberations.
Yeah, we can deliberate. Sorry about that.
so we can make a motion.
Yes,
if somebody
we can
wants-
make a motion at this
Or I
time.
can make it, but. You want me to make the motion?
If you want to, it's up to you.
No, it's,
Okay.
it looks like you want to.
Did you want to?
I can try.
For the sake of experience?
Sure. All right, so let's see here. In the matter of, 1 second, just putting up the script here. Should have the,
Here's the address.
okay, so in the matter of, let's see, here's it, Thermal Solutions Manufacturing. Located at 1390 South Tippecanoe Avenue, Suite B in San Bernardino. Regarding case number 6255-3, facility ID 172808. We are motioning to grant the interim variance, as stated already, with the conditions and the amendment that Mr. Balagopalan has brought forward. And we're also putting the date of the regular variance hearing for July
Right.
9th, I believe, was it?
Yes.
And
And the interim variance will be from today.
the interim variance would start on May 23rd and for 90 days, which was calculated to be in
Until the regular variance is heard, which is within the 90 days.
Okay, so then either 90 days or when the next regular variance is, which is July 9th.
Yes.
And then for they already met good cause. They meet the 6 findings as Mr. Balagopalan has already stated them, so I won't restate them. And it's required, yes, let me see, I don't have that right in front of me. 1 second.
Here,
Right here. All right, so regarding, let's take a look.
There's the equipment's right there.
Rule 1420 F1 and regarding the equipment, the lead pot furnace with permit number G26164, that we grant the interim variance.
Okay. Do I have a second?
I'll second it.
Second, Ali.
Just the excess emission estimated is about 0.001 pounds per day of lead.
Okay, that would be the requirement that we would allow.
I mean,
That's what they've stated.
Okay.
I just want to record Ali as being as the seconder of the motion.
Was that a second, Mr. Ali? I didn't hear it completely.
Yes.
Okay,
Second,
Mr.
yes.
Balagopalan. Thank you. Okay, any discussion on the motion?
Just one, Madam Clerk, did you get all the, sorry, the amendments that I was talking about? And you want me to go through that?
Did you have another amendment other than number 10?
Yeah, the condition number 2, it's sort of saying determined by the most recent AQMD test, determined by an approved AQMD source test pursuant to Rule 1420. And then on condition number 9, so calculate the excess emission fee and then insert calculated as lead, comma.
I asked you that earlier. You wanted to change the verbiage on number 9. Okay, as lead.
And then condition 10, you got condition 10, correct?
And out of that draft, condition 10, it just says petitioner shall clean the root cause.
Yes.
Using, let me just put, using approved methods in Rule 1420 and leave it open-ended to what method they use.
Would it be possible to say that that's contingent upon a visual inspection that shows that there's lead in the area, or would you prefer that they vacuum around the stack every month regardless?
Yeah, I think that my assumption, I could be wrong, that there is accumulation there, but if they've been cleaning it, but that's so.
Okay. One other item with respect to the excess emissions fees, because Thermal Solutions is looking at doing a follow-up source test that may ultimately show compliance. If it shows the same results as 2019, for instance, we would respectfully request that the board allows for that test date, if those results are certified by AQMD, to be the last, the end of the excess emissions fees, if it's shown that test was a passing test. So in other words, the excess emissions fees would apply for each day up until that source test date, and contingent upon that test showing a passing result and being certified by AQMD.
I think that's sort of a given because, then if you comply with the rule limit, there's no excess emission.
Right. There will still be some time after that source test is completed and all of that. So I just wanted to make sure that was something the board was aware of, that period of time that's going to elapse after the test is performed, but before South Coast certifies the result.
Are you in agreement with that, Ms. Reichert?
Generally, the district does not provide a position on excess emission fees, But as to.
I'm more concerned about the date process. the
Right, I
timing.
mean, so in terms of if the date of the source test, that would be the date demonstrating that, I mean, the date of the source test is the date the sample was taken, and that's the date that, you know, if later it is verified that they are in compliance, then that would be the date that they are in compliance as of that date. But there is a delay in terms of verifying that. So
That's my concern.
yes. So I do not in theory object to his statements that he's making, but in terms of whether the board wants to accept the request, the district does not take a position on that aspect for excess emission fees.
But Madam Chair, just a process check.
Repeat that, Mr. Ali?
Yeah, just a process check and just a point of order, as it were. Where we've already made the motion, there's a motion in seconds. So help me understand where we are within the deliberation
Well,
process.
what we were on was that Mr. Balagopalan was making some friendly amendments to the motion. And that's how this has all taken place in regards to his corrections on the motion.
After it's been seconded, I'm just a little confused.
It was just an amendment to the motion. And then we have the ability to have discussion of the motion.
I think just for, I think Ms. Dali's point too, is we'll leave it as is, and when they come back for the regular variance, we can take it up.
Then,
Yeah.
Thank you, sir. Thank you, Mr. Balakapalan, for clarifying that. Thank you.
okay, so is that it for your
Yeah.
amendments? Okay. All right, so it's been seconded, and is there any discussion beyond what we already have on the motion? Seeing none, let's go ahead and vote. Mr. Ali, how do you vote?
Aye.
Dr. Abraham?
Aye.
Mr. Pearman?
Aye.
Mr. Balagopalan?
Aye.
And I also vote aye, so it's unanimous that you are granted the interim variance.
Thank you.
And we will
Thank
see
you.
you on July 9th.
Thank you very much.
Thank you, everybody. Thank you, board members.